It is possible after employing the subsidiarity diagram and the subsidiarity principles that there might still be more than one source of law that could be relied on. Now, irrespective of whether one or more sources are indicated by the subsidiarity analysis, the results of the subsidiarity principles and the subsidiarity diagram must always be subjected to the desired characteristics and unwanted effects test. So basically then the angle of approach consists of two legs or two parts. The first one is employing the subsidiarity diagram, and then once establishing the type of legislation, if there is any legislation, applying the subsidiarity principles. In the event that there's no legislation, directly applying the subsidiarity principles, and then filtering through and finding the most appropriate source of law in terms of the subsidiarity principles, or sources of law in terms of the subsidiarity analysis. What then needs to happen, as just stated, is the desired characteristics and unwanted effects test must be applied. Now, where only one source survives the subsidiarity analysis, the desired characteristics and unwanted effects test will confirm whether the source indeed promotes the single system principle as well as the spirit, purport, and objectives of the Bill of Rights. While in the event of more than one source surviving the subsidiarity analysis, the desired qualities and unwanted effects test will show which one of the sources promotes the single system principle and the spirit, purport, and objects of the Bill of Rights most. So therefore, the desired qualities and unwanted effects test is really a further a test that is applied to get us to the most appropriate source of law in the constitutional dispensation. All right, so what is then the basis of this test? The basis of the test is Section 39 of the Constitution, which requires that all law must promote the spirit, purport, and objects of the Bill of Rights. The property law system that operates under the Constitution must therefore promote the spirit, purport, and objects of the Bill of Rights. Now, a property law system that promotes the spirit, purport, and object of the Bill of Rights must have certain qualities and avoid other effects or certain effects. And this is where the desired qualities and unwanted effects test comes in. We apply this test to determine if these certain qualities that we want to see in our constitutional dispensation are evident and present in the source that we choose, and whether or not it is devoid of those unwanted effects that we do not want to see in our constitutional property system. So then what does the desired qualities and unwanted effects test look like? So it consists of a number of considerations, and as you'll see on the slide, we have consideration 1 to consideration 5. Now, the first one is that the source of law must be formally valid and of general application. Now, how does one establish validity? So, to establish whether or not a source is valid, we have to look at whether it has been repealed or is it still in force. And this requirement is grounded in the rule of law and is prevalent in several provisions in the Constitution. For instance, if you look at Section 25, when you test a provision in legislation or common law rule against Section 25, there's also the validity question that comes in. Is the source or the provision or the rule valid? So it's really based on the rule of law, and that we have valid rules and laws that regulates us. Now, the second part of this formal validity and general application is the general application part. And how do we determine this? It's determined by the fact that it is adopted, or it's determined by looking at whether or not the source is adopted and promulgated publicly, and whether or not it is prospective in effect, and determining whether or not it is expressed in an understandable terms, if it is consistent with the other provisions, and whether or not it requires conduct beyond the powers of the people. So if it does, then it will not be of general application. And also making sure that it does not change so frequently that people cannot arrange their affairs and actions, and also in determining and making sure that it is administered in a manner consistent to its wording. So these are all the considerations that will tell you whether or not a specific source is generally applicable. So that's in the first consideration. The second consideration concerns the following. The source of law should also promote the general features or characteristics that we want to see in our constitutional democracy. Now, the general features concern the promotion and protection of basic rights in the Bill of Rights, such as, first of all, the inherent human dignity of every person as enshrined in Section 10 of the Constitution. So if the source of law does not protect the inherent human dignity of every person, then you would say that the source of law does not have this general feature and therefore does not have this desired quality, and does really then not meet or satisfy the test. So it would then not be an appropriate source in the source of property law, and in that regard we will have to then think about how we're going to make sure that it's either aligned with the Constitution, so thinking about development, or interpret it in a way that it can be still acceptable in the constitutional dispensation. So here we're talking about reading down or reading in, etc. The same then applies for another general feature, such as the equality. So the source must promote equality as enshrined in Section 9. The source must promote administrative justice as enshrined in Section 33. And the source must also promote access to courts, so as enshrined in Section 34. In addition to these general characteristics, the property system and therefore the sources should further recognize the following specific characteristics or features. So this is consideration 3, specific features. These are: the source has to accept that regulation of property is lawful, natural, and unavoidable. It must be clear from a review of the source or the specific provision in the source or the principle that a balance is maintained between public interest and individual interest. The source must also not allow for arbitrary deprivations of property, so Section 25(1). And the source must also not allow for arbitrary evictions from homes. Now, when we looked at the subsidiarity diagram, I said to you that where a litigant decides to challenge a provision in the legislation because it is unconstitutional, or insufficient, I noted there that I'll refer back to that when we get to the desired qualities and unwanted effects tests. So when a litigant challenges a provision in the legislation based on the fact that it is unconstitutional, or arguing that it is unconstitutional, and in the context that we're speaking, the litigant is arguing that it is infringing its Section 25 right. In other words, it constitutes an arbitrary deprivation of his or her property. This is then where the desired qualities and unwanted effects test comes in, because the legislation or the provision must not be arbitrary, or arbitrarily deprive someone of their property in order for it to survive the desired qualities and unwanted effects test. So if it doesn't meet this requirement, or if it does constitute an arbitrary deprivation, then it's an indication to you that the court can, that the litigant would be able to challenge the provision in the legislation in terms of proviso 1 of the subsidiarity principles. So just make sure that you understand this link that I just explained. All right, so then lastly, a property system should ensure that legislation gives effect to the following reformative goals in the Constitution. So the point 4, or the fourth consideration there, is that the provision or the legislation or the source must give effect to land reform objectives or at the least not infringe on or hamper land reform objectives. So what are these land reform objectives? It's the promotion of access to land, security of tenure, restitution and redistribution, and also the progressive realization of Section 26(1), namely housing. So where you have legislation or provision that hinders or hampers access to land, security of tenure, restitution or redistribution, or puts a stumbling block or a challenge, a negative challenge, in front of the progressive realization of access to housing, then you are dealing with a piece of legislation that does not promote the land reform objectives, or that hinders it, and the piece of legislation will not survive the desired qualities and unwanted effects test. Okay, then finally, in light of the above, a property system should not have certain unwanted effects or causes, or exacerbate these certain effects. And what are these things? So the source should avoid or prevent insecure tenure, landlessness, and homelessness. So these qualities were identified, all of these considerations and their detail that we've just unpacked, were identified by Van der Walt in the prescribed chapter 2 of Property and Constitution. Van der Walt argues that these characteristics and the unwanted outcomes can be linked to the general constitutional aims and transformative goals stated in the various provisions of the Bill of Rights. Therefore, in promoting the spirit, purport, and objects of the Bill of Rights, a property system must display these characteristics and avoid the unwanted effects. When determining which is the most appropriate source of law between different options, it must be established whether and to what extent each of the sources, with their specific eligible causes of actions, promote the principle of a single system of law which demonstrates these characteristics while avoiding unwanted outcomes. So by way of summary then, when having to decide what source of law should be relied on, where there is more than one applicable source, the point of departure must be the single system of law principle. And the single system of law principle then tells us that there are two other steps to follow, or two steps that need to be followed in order to give effect to the single system of law principle as laid down in pharmaceutical manufacturers. The subsidiarity principles and their together with the desired qualities and unwanted outcomes effects test must then be applied as a means to give effect to the single system of law principle. Together, the above test steers one into the direction of the most appropriate source of law from a constitutional perspective. And as you would have also noted when we spoke about the desired qualities and unwanted effects test, it will not only steer us into the direction of which is the most appropriate source, but it will highlight to us and indicate to a court specifically which sources are highly problematic, or remedies in sources are highly problematic that should not be left unchecked, that should be struck down, read in, or developed in order to get it in line with the Constitution. Thank you for your attention and participation in this presentation. On this last slide, I just want to refer you to some sources that can assist you with better understanding or provide you with some examples of how one would go about doing subsidiarity analysis, as well as the application of the desired and unwanted effects test, and how that then assists us with establishing which source in a given situation is the most appropriate source within our constitutional, within our property law system that promotes the constitutional vision and purport, spirit, and objectives. So please have a look at those sources and to confirm and strengthen your understanding and also application skills of this part of the work.